Good evening to you all, and welcome to our Company Law 1 class. Tonight, we are continuing discussion of the topic we started at our last meeting, forms of business organization or models of business organization. And in the previous lecture, we discussed the various options which are available to a person or a group of people who are looking for an appropriate vehicle to use to run their business. So we look at where the person decides to just go by himself or herself without any strict legal requirements, as in sole proprietorship. We saw that there are virtually extremely minimal or no legal requirements at all to get that. And we look at the benefits and then the demerits of having such a mode. That we also reminded ourselves that if a person decides to use a name other than his true name, then he or she is required to register what we call business name. And if you have a business name, there's a law called the Registration of Business Names Act, which requires you to register and to renew it annually. But then we reminded ourselves that having a business name registered does not confer any legal status in terms of legal personality on the business. The business will remain the same as the sole proprietor. Then we also move on to discuss incorporated private partnership. And we noted that incorporated private partnership is seriously regulated in our jurisdiction. And for that matter, we need to pay attention not to confuse some of the ideas which exist under old English common law. And we made the point that as far as our jurisdiction is concerned, if you don't register, you don't have incorporated private partnership. It doesn't matter that you'll be running like one. The law will not recognize that as the vehicle, which is supposed to be incorporated private partnership, so as to accord the necessary legal privileges and incidents that go with that. So we noted that. And we also look at certain forms of associations or certain arrangements, which on the face of them, they have the appearance of a partnership. But the lawmaker has expressly stated in Act 152, the Incorporated Private Partnership Act, that such associations or arrangements are not incorporated private partnership for purposes of our law. So tonight we want to discuss another model of business organization, and in fact, that is the main concern of this course, as it were, and that is what we call incorporated companies. Incorporated companies. So mind you, I did not just say companies, I said incorporated company or incorporated companies. That is to say that you must follow a certain prescribed legal regime or processes before you bring such a business model or vehicle into existence. So it becomes incorporated. For that matter, if you look at our law, that is the Companies Act 2019, Act 992. The point is made that one or more persons have the right to form an incorporated an incorporated company, not incorporated private partnership, incorporated company under Act 992. And I'm referring you to Section 6 of Act 992, which put it simply that one or more persons may form an incorporated company under this Act. Now, you will come to appreciate from the history of the company law that we did the last two lectures that the incorporated company, in the eyes of the law, is regarded as an entity in its own right, or to put it in other words, it is given the status of what they call a legal person, a legal personality. We'll come and discuss more of that very soon. Now, by Section 7.1 of Act 992, incorporated companies exist in 4 types, namely a company limited by shares, a company limited by guarantee, an unlimited company, and an external company. Let's say one sentence about each of them. Later we come and discuss them with a little bit more discussion. So a company limited by shares is a company in which liability of the members is cap in the sense that where the business run into hard times and there are debts and liabilities, and the assets of the company, for example, are not enough to pay all creditors, meet all debts and liabilities. The members, who are the shareholders, cannot be called upon to contribute more money to enable the company meet those debts and liabilities. All that they stand to lose will be the amount of money they invested in the company as a payment for the shares which they have. So if things are not going well, the company is insolvent or bankrupt, and then there's going to be no liquidation, you will not get your money back if there are more debts to be met. But even where there are still more debts, nobody can ask you to make more money because you have told the company that in terms of liability, in terms of meeting debts, you do not want to expose yourself more than the amount of money you have paid for the shares that you have in the company. It follows, therefore, that where you have not finished paying for the shares that were issued to you, then during winding up or liquidation, you will be called upon to come and pay the unpaid balance, the portion of the price of the shares which you haven't yet paid. You'll be called upon to come and pay. But once you have paid that, even if there are still more there to be met, nobody will ask you to make more payment because your liability is limited by what? By shares. So a company limited by shares simply means that the members or the shareholders have indicated that they do not want to bear any debts of the company over and above the amount of money represented by the shares that they have in the company. So if there's anything at all, what they stand to lose is their share, value, or the money that they put in the company for the shares. Now, commonly limited by guarantee, on the other hand, is where the members of the company have not actually paid any money to the company, but have made undertaking that should it become necessary that the company has run into debts and money is needed to meet those debts, and the company is being liquidated or is winding up, then I am prepared to contribute 1,000 Ghana cedis or 5,000 Ghana cedis or 10,000 Ghana cedis. Once I have made that undertaking or that guarantee at the formation of the company or when I became a member of the company, nobody can ask me to pay more than that should the need arise in the life of the company. So therefore, in a company limited by guarantee, your liability, that is how much of the company debts that you'll be asked to pay, is no more than the amount of money you indicated as that you are prepared to contribute. So let's keep that in mind. Then we also have an unlimited company. An unlimited company, as the name suggests, there's no cap on your exposure to the indebtedness of the company. In that case, with liability side, you are not in any significant different situation from the sole proprietor, as it were. Because for the sole proprietor too, there's unlimited liability. Maybe the only difference is that there are some other privileges which you enjoy because you are an incorporated company, which a sole proprietor will not get. But with respect to liability, you are practically in the same situation. Then you also have external company. An external company here is with reference to what we call the nationality of the company. And the nationality of the company simply means in which jurisdiction, in which country was the company registered. Therefore, all companies which are not national companies, not having been registered under Ghanaian law, and are registered or incorporated in other jurisdiction, but they have a place of business in one way or the other in Ghana, they are treated as external companies. External companies. So let's keep that in mind. Now, having briefly clarified these four types at the very early stage, it is pertinent to also appreciate that the main purpose of incorporated company is either to carry on business and distribute the resultant profits among the members, or to carry on a social venture which is not profit motivated, and especially for the community by guarantees, is not really set up necessarily for profit, but usually for a cause, a particular need. So if profits will even be made at all, no profit be made to be shared among the members, but to further the cause for which that company was incorporated or established. So let's keep that in mind. Another point worth noting is that incorporated companies may be private or public. So in terms of section 7, subsection 4 of Act 992, the provision is to the effect that the company of a type specified in subsection 1, that is the ones that we've gone through, may be private, may be a private company or a public company. And the question arises, what is a private company and what is a public company? Now, before I move on, let me remind you that, sorry, I have a little bit of food. Oh. Yeah, so let me remind you that company law, as I indicated in our very first lecture, the introductory lecture, company law is not necessarily difficult, but it is technical. Technical in the sense that because the law is heavily statutory law, you cannot do a guesswork. You either know it or you don't know it. So, for example, when we say a private company as opposed to public company, you cannot just use, what my friends in Commonwealth, Vanda City or Katanga will say, native intelligence or home sense. You cannot just use that just to try and explain it. You must know what the law says. So therefore, under section 7, subsection 5, we are giving the distinction between a private company and a public company. So, a private company other than a company limited by guarantee is a company which, by virtue of its constitution, and I want us to pay attention to that, which by virtue of its constitution. So it is the constitution of the company which is giving us certain indicia, certain markers, which let it be a private company. And what are those markers or those indicia? And that is what we have in A to D. So A restricts the right to transfer its shares, if any. So there is a restriction on transferability of shares. In a private company, you cannot just transfer your share to anybody of your choosing. No, there are restrictions. And of course, for good reason, private companies to large extent are small to medium-sized companies. And some are even like the close family companies. And for that matter, you want to have a control of membership. It's not anybody at all who should be allowed to come in. And that is why there's that restriction on transferability of shares. Then another feature of private company is that the constitution limits the total number of the members. The total number of the members and the debenture holders to 50. So the total membership of a private company is 50, but even this 50, how it is arrived at, we have to look at I and II. Certain persons have been excluded in arriving at the 50. So one person who are generally in employment of the company, and persons who, having been formerly in the employment of the company, were while in that employment and have continued after the determination of that employment to be members or debentures holders of the company. Now, this is important. Later on, when we are discussing corporate finance, and you're looking at the doctrine of capital maintenance, we will come across the principle on prohibition of financial assistance. The rule in Trevor and Whitworth, which to some extent also reflects what we have in our law, that a company should not provide financial assistance for subscribers to acquire its own shares. Exception is provided, and one of those exceptions is that where you were in employment or you're an employee and the company has, for example, set up some funding scheme to enable employees to get money to buy shares of the company so that they have a stake in the prosperity of the company. Now, when we are counting the number of the private company, like the 50, when we are trying to get at the 50, then section 7, 5, B, I, and II say that even though every shareholder is a member of the company, employee shareholders will not be counted as part of the 50. And then former employees, shareholders, that is, those who were employees and at the time that they were employees, they got shares in the circumstances that I have explained. When we are trying to arrive at the 50, we also exclude them. So that is what we should take note. So the takeaway is that the maximum membership of private company is 50. But then it excludes persons who are bona fide in good faith in the employment of the company or who were formerly bona fide in employment of the company. So that is what we should keep in mind. Then C, it prohibits the company from making an invitation to the public to acquire shares or debentures. So this is another important qualification. If you take private companies, they cannot just go to the public to actually source for funding. So they cannot make invitations to the public. They cannot advertise and say that we are looking for money, we have shares, come and take our shares and then invest in the company, or come and give us a loan by way of the debenture. Debenture is a long-term loan. Come and take a loan, give us a loan, we give you a debenture, and there's that prohibition that a private company cannot actually do that. Another marker of a private company is in D. It prohibits the company from making an invitation to the public or deposit money for face period or payable at call, whether bearing or not bearing interest. Yes, so private company too can also not call upon the public to come and deposit funds, as it were. And indeed, it is for that reason that a private company can actually not do the business of banking, in a sense, because of this prohibition. And indeed, if you look at the banking industry in Ghana, for a long time, the Rural Bank and also Bank of Ghana, if I may say, probably overlook this aspect of the law. No wonder, following the sweeping reforms the Bank of Ghana has sought to do in corporate governance, rural banks have had to re-register as a public limited company because clearly a private company is prohibited from making an invitation to the public to deposit money for fixed period or payable at call, whether bearing or not bearing interest. And if you're in the business of banking, what do? Don't you call upon the public to come and deposit money? Yes, and that is why a private company could not be licensed to do the banking business in a sense. Let us also look at section 294 and 295 of Act 992, which provide rules which governs invitation to the public. So if you have your law, just jump to 294 and then 295. Somebody should just read the 294 subsection 1 for us. You don't have your law? Okay, let me see if I'll be able to update my. I told you, anytime you're doing company law, you must have your law with you. Yes, somebody's hand is up. Uh, okay. Yes, you can release.
Section 294. Section 294. A person shall not make an invitation to the public to acquire. A person shall not make an invitation to the public, A, to acquire or dispose of any shares or debentures of a company, or B, to deposit money with a company for a fixed period or payable at call, whether bearing or not bearing interest, unless the company concerned is a public company and the appropriate provisions contained in Part A of Chapter 4 are duly complied with.
Okay, so I'm just interested in that portion which says that unless the company concerned is what? It's a public what? Company. Good. So let us keep that in mind. Later on, we will discuss invitation to the public when we are discussing details of corporate finance later on. But just for this occasion, just wanted to let you know how important is the distinction between a private and a public company. So let's keep that in mind. Then what about 295? 295. Somebody should read it for us so that we have an idea what it means to say public, invitation to public. Yes, 295. Yes, Benedicta or Benedict. Yeah.
Section 295. Hello.
Yes, go ahead.
Yeah. For the purposes of this act, an invitation is made to the public if an offer or invitation to make an offer is A. Advertised or disseminated in the Republic by newspaper, broadcasting, cinematograph, electronic communication, or any other means. B. Made to or circulated among persons, whether selected as members or debenture holders of the company concerned, or as clients of the persons making or circulating the invitation, or in any other manner. C. Made to one or more persons on the terms that the person or persons to whom it is made may renounce or assign the benefit of the invitation, or of shares or debentures to be obtained under the invitation in favor of any other person. Or D. Made to one or more persons to acquire shares or debentures dealt in on a stock exchange, or in respect of which the invitation states that application has been or will be made for permission to deal in those shares or debentures on a stock exchange, subject to subsection 5. 2. Subsection 1 does not require an invitation.
Yeah, please jump even to subsection 3.
Okay. Subsection 3. For the purposes of subsection 1, an invitation made by or on behalf of a private company exclusively to the existing shareholders and debenture holders of the company, which is not greater in number than is prescribed by subsection 5 of section 7, and its existing employees, is not an invitation to the public unless the invitation is of the type referred to in paragraph C or D of subsection 1.
Good. So you notice that under section 295, we are being told that if in a private company, invitation in a loose sense, for example, is made to the members not exceeding 50, and then excluding members who are employees and became members, or members who were employees and became members are no longer employees when they are disregarded from the 50. So long as the invitation does not go beyond that number, it's not treated as invitation to the public. So let us keep that in mind. So therefore, a company which is not private company is a public company, except a company limited by a guarantee, which has a membership of 50 or less. So let's keep that in mind. If you are not a private company, then you are a public company. So let's keep that in mind. So therefore, if you ask to explain a public company, it is the reverse of what we know about private company. Of course, the exception is the company limited by guarantee, which has a membership of 50 or less. It must also be noted that an incorporated private company could be converted to an incorporated public company. So let us also keep that in mind. It is possible if you were a private to be changed to become a public company. So let us, for example, look at section 302. Please, somebody should read section 302 for us. Section 302. Well, let me see if I can project it. And 302. Yeah, I think I have it here. And so conversion of a private company to public company, section 302. A private company shall be converted into a public company. Let me allow one of you to read it for us so that we hear your voice. Yes, Ade.
Yes, please, my lord.
Yes.
Conversion of private company to a public company, section 302,
Let me redo.
subsection 1. A private company shall be converted into a public company. A, if
Sorry.
the company alters its capacity to operate as a private company.
All right.
And B, where the company alters its registered constitution in a manner that is appropriate to a public company and not required in order to constitute a private company. 2, within 28 days after the date of special resolution to alter its capacity to operate as a private company or alter the registered constitution, the company shall deliver to the registrar for registration a copy of the resolution in accordance with section 165. 3. The registrar shall publish notice of the convention of the company in the company's bulletin. 4. Where there is a default in complying with subsection 1 or 2, the company and an officer of the company that is in default is liable to pay to the registrar an administrative penalty of 500 penalty units.
All right. Okay. Thank you very much. Yeah, so that is it. So just to remind us that it is possible for a private company to be converted to public company so long as the requisite special resolution is passed and then registered with the registrar general and the publication is made in the company's bulletin, which is a gazette for purposes of company law and commercial notification by the regulator. So therefore, we also note that an incorporated company is a juristic person. When we say juristic person, that is to say that is a person created in law. It's not a natural person. You and I are natural persons, but the law can also use legal imagination to recognize a person who does not have flesh and blood. So that is a juristic person. So a company is a juristic person, separate and distinct from its members and officers. The law sees the company as standing in its own right, separate from the members or the office and officers. And legal personality, legal standing, locus standi is important because it is that which will enable you to have rights and responsibilities or liabilities. So if the company is a juristic person, separate and distinct from its members and officers, it follows therefore that the rights and liabilities of the company are not the rights and liabilities of members, except in circumstances where the metaphorical veil of incorporation is lifted, as you will be seeing in the course of our discussion. So let's keep that in mind. So I asked you to read the case of Salomon and Salomon. And then the last time I gave you a little bit of a preview of it. Can somebody tell us what the facts, the issues, and then the holdings were in Solomon and Salomon? Yes, who will try? We can ask you to read it. Yes, who will tell about Solomon and Salomon? Hello? Are we together? Morkor and Kuma. No, but let's do Solomon and Salomon. Oh, Edward in Cancer. Okay. Edward. Edward, yes, you can talk. Edward, you can mute yourself. Yeah.
Yeah. Thank you, my lord. In the case of Salomon, and he registered the company as an incorporated company and made his family members as shareholders in the company. So the company ran into crisis, and he was sued to be held responsible for the debt or the crisis that had come to the company. And then the holding was that he could not be charged for the liabilities of the company because the company is a separate legal entity. And so he was not held liable for the misfortunes of the company.
Yeah, I mean, it's a noble attempt. Will anybody try it again? Please, I'm giving you assignment. Go and read the full judgment of Solomon and Solomon, the High Court decision, the Court of Appeal, and then the House of Lords decision. Who has read Morkor and Kuma? Morkor and Kuma. Please be reading the cases. I won't tell you. we also need to note this point about incorporated company, that there's a separation of management and ownership. So management and ownership of incorporated companies are not fused. In most cases, the affairs of the company are run by persons who may or may not be members of the company. Of course, it's permissible for the members or the shareholders to also be the directors running the company, but it need not be like that all the time. So once you go through the procedures for incorporation under Section 14 of Act 992, the company becomes a body corporate and thus has full powers and capacity of a natural person to undertake any business or enter into any transaction. So somebody should read Section 14.2 for us. Another person should read Section 18.1 of Act 992. Yes, you can release yourself and speak. Section 14.2. Reading to let's open your law and read Section 14.2 for us.
Yes, Counsel. My Lord.
Yes, go ahead.
Please, Section 14.2 says, from the date of incorporation, the company becomes a body corporate by the name contained in the application for incorporation and subject to Section 13, is capable of performing the functions of an incorporated company.
Good. So Section 14.2 is very important, telling us that the incorporated company is actually born. It's born on the day of registration or the day of incorporation. And then becomes like a body corporate by the name contained in the application for incorporation. And another thing I like is the fact that and is capable of performing functions of an incorporated company. Capable of performing functions of an incorporated company. So it acquires powers. And to give us a sense of what the powers of incorporated company are, let's look at Section 18, subsection 1. Who will read for us? Section 18, subsection 1. Yes, go ahead. And there, go ahead.
Section 18, subsection 1. Subject to this act and to any other enactment, a company shall have a full capacity to carry on or undertake any business or activity, do any act or enter into any transaction, and B, full right, powers, and privileges for the purposes of paragraph A.
Yes.
2. All right.
Yeah, we'll come and discuss that later on. But for now, Section 18.1. If you remember your law of contract, you discuss capacity to contract. And we talk about capacity of adults, minors, corporations, and so on. Yeah, so the corporations or the company, it's a body corporate. And the law is telling us that it has full capacity. It has full capacity in terms of Section 18.1 to carry on or undertake any business activity or enter into any transaction. So whatever transaction or contract a natural person can enter into, as a general rule, the company as a body corporate can also enter into it. An incorporated company may be registered with or without a constitution. So it's not mandatory for a constitution to be drawn up and submitted for registration before you can get incorporation. Unlike incorporated private partnership, where it is the law that the deed of the partnership agreement should be submitted for registration. For incorporated companies, under the current law, it is not mandatory for constitution to be adopted. There is what we call a default constitution provided in the law. If you don't have your own, then certain default rules have been provided for you. And that is what section 23(1) is telling us. So on your own, you read section 23(1). A company has the option to have a registered constitution, just that. Now let's say a few words about the various categories of companies. So company limited by shares. As we have explained earlier tonight, that a company limited by shares is a company which has the liability of its members limited to the amount unpaid on the shares, respectively held by them. And that is what section 7(2)(a) tells us. And as I've explained, where the company is registered with shares, the members, by statutory requirements, must have shares, at least a share each. And shares are supposed to be paid for. Shares are not free. So if you are giving shares, you have to pay for the shares. And sometimes you may not have to pay the full price of the shares when they are issued, depending upon the agreement under which the company issued the shares to you. It may well be that part of the price is required to be paid, and then the other remaining balance will be required at future date when the company make a call on you or serve a demand that you come and pay. Now, supposing you have not finished paying and the company, for example, becomes insolvent and is being liquidated. The company has so many debts. You are looking for whatever the company assets and money are to try and use to satisfy these debts. Now, when it gets to that stage, what will happen is that shareholders who have not finished paying for the shares which were issued to them will have to come and pay. And for shareholders who have fully paid for shares which were issued to them, for them, nobody can ask them to make any additional or further payment as the case may be. So, a company limited by share must always be registered with shares. It must always be registered with shares. Otherwise, it's not a company limited by shares. And the company, once incorporated, has the power to create and issue shares. Now, under the current regime or dispensation, particularly in terms of Section 21 of Act 992, the company limited by shares is supposed to have certain suffixes, that is, endings added to their names. So therefore, if the company limited by shares is a private company, right? It's a private company limited by shares, then it is required that all the time, either the abbreviation LTD will be written at the at the ending of the name. So we have Ujakrum Limited. So that should tell you that the Ujakrum Limited is a private limited company, a private company limited by shares. Or if you see something like Bosomtwe PLC, that is to tell you that the Bosomtwe public company limited by what? Limited by shares. So PLC, that is it. So let's keep that in mind. Now, a company limited by share can also metamorphose to become a company limited by guarantee. It is convertible. So let's look at Section 9 of Act 992 on the procedure for conversion of a company limited by shares to a company limited by guarantee. And before we do that, one may be interested in finding the rationale for a company limited by shares being converted to become a company limited by guarantee. Now, as we noted, a company limited by guarantee is not actually set up to run for profits to be distributed among members, but is for a particular cause, right? And if profit is made at all, the profit will be in furtherance of the stated objects or the cause for which the company was actually registered. Now, you have a company limited by shares. Maybe enough money have been made, or the members will say that for whatever reason, we want to actually use this company to do certain things which will benefit society. So, for example, you want to promote protection of the environment, or you want to promote maybe research into malaria or anything. Now, where that is the case, then you have to bring yourself within the procedure in Section 9 so that you're able to convert the company limited by shares to a company limited by guarantee. So somebody should take us through Section 9. I've told you should all have your law with you all the time. Yes. Yes. I do have ladies in this class. Or they don't like talking. Okay. Yes, Benedict. Let's hear you.
Section 9. A company limited by shares may be converted into a company limited by guarantee if A, the liability on any of its shares is fully paid. B, all the members agree in writing to the conversion into the voluntary surrender to the company for cancellation of the shares held by them immediately before the conversion. C, a new constitution appropriate to a company limited by guarantee is adopted by the company pursuant to Section 30. And D, a member agrees or the members agree in writing to contribute to the assets of the company in the event of the company being wound up to an amount of money not less than that prescribed by Section 3 of Section 8. 2. On delivery to the registrar of registration of a statutory declaration by a director and the company secretary confirming that the conditions of subsection 1 have been complied with, the registrar shall issue a new certificate of incorporation to the effect that the company is limited by guarantee. 3. From the date stated in the certificate, A, the company is converted into a company limited by guarantee. B, the shares in the company shall be validly surrendered and cancelled despite the provisions of Section 58. And C, the members of the company who have not agreed to contribute to the assets of the company in the event of the company being wound up cease to be members of the company. 4. Except in accordance with subsection 4 of Section 21, the company shall not change the name under which the company was registered before the conversion. 5. The omission of words A, PLC, that is Public Limited Company, or B, LTD, that is Private Company Limited, as the last words of the name of the company after conversion shall not be regarded as a change of name. 6. If the registrar is of the opinion that the name under which the company is registered will be misleading or undesirable on its conversion to a company limited by guarantee, the registrar shall, in accordance with subsection 6 of Section 21, direct the company to change its name and shall not issue a new certificate of incorporation until the direction has been complied with or cancelled in accordance with that subsection. 7. Until a new certificate of incorporation is issued under subsection 2, neither the surrender of the shares of the company nor the agreement to contribute to the assets of the company in the event of the company being wound up shall take effect. 8. The conversion of a company pursuant to this section shall not A, affect the rights or obligations of the company, except as mentioned in this section, or B, render defective any legal proceedings by or against the company.
Right. Thank you very much. Yes. Now, I want somebody to attempt an explanation of why in section 9, 1A, there is a requirement that before a company limited by shares may be converted into company limited by guarantee, the liability on any of its shares should be fully paid. Yes, anybody? Why is that necessary? Why should there be no unpaid liability in respect of the shares of a company limited by share, which is going to be converted to a company limited by guarantee? Yes. Why is that necessary?
If I can try.
Yes, please, Albert. Thank you.
Please, I think the reason being that company limited by guarantee is not meant for profit-making purposes. And for that matter, in the course of conversion, there shouldn't be any liability transferred to it becoming a company limited by guarantee.
Okay. Thank you, Albert. Any other?
Okay, so my lord, I also think that you said that a company limited by guarantee is where the members have not paid any money to the company, but have signed an undertaking stating that in case the company is liquidated, they are ready to pay so and so amount of the money and not more than that amount. And so to transfer an amount, to convert to a limited guarantee status would also imply that the debt or the liabilities of the company wouldn't be paid. And so it will be more prudent to clear the debt before you change the status from a company limited by shares to a company limited by guarantee. Because with a guarantee, there's no certainty that the company's liabilities will be catered for unless it meets the standards or the amount which the members agree to cater for.
Okay. All right. Thank you. Yes. Any other?
Yes, my lord.
Yes. Go ahead.
Company limited by guarantee, members agree to pay some pledge amount in the event that the company becomes insolvent and there's liability for them to pay.
All right. All right. Thank you very much.
The shares that they have bought or the unpaid outstanding share amount in case the company runs into liquidation and there's liability for them to pay. So therefore, if they are converting from limited liability to guarantee, then they have to ensure that every member has actually paid whatever shares that he owns and other things, so that they can smoothly move from this point to the guarantee. And those who are not willing to join, as some of the provision or sections indicated, then they quit. That's my view. Thank you.
Yeah, I think I mean you're all right. There's so much wisdom in the provision, section 91A of Act 899 of Act 992, requiring that the liability on any of its shares is fully paid before a company limited by shares can be converted to guarantee. Now, it's a sort of like a protection for creditors. Why is it so? After all, people who are dealing with the company limited by shares, they have they take it for granted that the issued capital, that is the money paid for the shares issued, is a sort of like a fund or a buffer, which will be used to satisfy debts that the company may owe. And for that matter, should it happen that a company limited by shares could actually convert while its shares were not fully paid, it would effectively allow the members to evade their unpaid capital obligation to creditors. So this requirement of the law ensures that creditors of the company are not unfairly prejudiced by the change in the legal form, moving from company limited by shares to company limited by guarantee should not really prejudice or undermine the right of creditors, as it were. And in fact, if that were not the case, there will also be abuses. Conversion from company limited by shares to company limited by guarantee will become a convenient device or a stratagem for escaping debts. If the company realizes that it's becoming overwhelmed with debt and so it doesn't want to pay, okay, then it gets the members to agree, let's pass a resolution to quickly cease being a company limited by shares and become a company limited by guarantee. If it were that simple, and then we didn't have section 9(1)(a), there will certainly be abuse, as conversion will become a convenient means of trying to evade or escape debts which the company may have. Now, let's say a few words about company limited by guarantee. A company limited by guarantee is a company which has the liability of its members limited to an amount that the members may respectively undertake to contribute to the assets of the company in the events of being wound up. So as we have explained, the members would make a formal undertaking that should there be debts and liabilities, this is how much I'm prepared to contribute to help the company to meet it. Now, Section 21C of Act 992 requires that the name of a company limited by guarantee should have the suffix as LBG. So if you have something like Center for Human Rights and Advanced Legal Research, assuming it's a company limited by guarantee, then we have LBG at the end of it. And by definition, a company limited by guarantee is not registered with shares and has no power to create or issue shares, because that will be a conceptual flaw. I mean, conceptually, a company limited by guarantee does not have shares, so why will it want to create shares? And again, Section 8(1) stipulates, among others, that a company limited by guarantee shall not be incorporated with the object of carrying on business for the purpose of making profits, other than making profit for the furtherance of its objects. So let's also keep that in mind. And mind you, we are not saying that a company limited by guarantee cannot make profit at all. There is a certain concession in the law, and I want somebody to read Section 8, subsection 1 and 2 for us. Please, somebody should read that for us. Section 8, subsection 1 and 2.
Section 8, subsection 1 and 1. A company limited by guarantee shall not be incorporated with the object of carrying on business for the purpose of making profits other than making profits for the furtherance of its objects. 2. Where a company limited by guarantee carries on business for the purpose of making profits other than for the furtherance of the objects of the company, the officers and members of that company who are cognizant of the fact that the company is so carry on business are jointly and severally liable for the payment and discharge of the debts and liabilities of the company.
All right, so that is fine. But what I want us to really note is the 8.1, that shall not carry on business for purpose of making profit other than making profit for the furtherance of its object. So, as a general rule, a company limited by guarantee is prevented or prohibited from making profit. But there's an exception. The exception is where it is going to make a profit, not to be distributed among the members, but to be used in advancing the objects or the purposes for which it was set up, then that is permitted. So let's keep that in mind. In the case of company limited by shares, when profit is made, the profit is made just to grow shareholders' value and then to distribute the profit by way of dividends to the shareholders. So that one is quite straightforward. But company limited by guarantee, making profit to be shared is prohibited. But making profit for the profit to be used to further or advance the object or the purposes for which the company limited by guarantee was set up is permitted. Let's keep that in mind. Yeah, so we've talked about the fact he read it, that the veil of incorporation will be lifted if the company limited by guarantee breaches the provision of section 8.1. In other words, if the members of the officers ignore the legal restriction that profit should not be made for the sheer sake of making profit to be shared, and they go ahead to really do that, then they have breached the law, and the company will not be held directly responsible. Human beings who were in charge of the company, when the company was making profit, will be held responsible. We move on to unlimited liability company. Unlimited liability company is a company which does not have a limit on the liability of its members. There's no cap. So it is registered with shares, and upon incorporation, it is enveloped with the power to create and issue shares. And it's supposed to have PRUC at the end of its name if it is a private unlimited liability company, and PUC if it is a public unlimited liability company. Now, before we move on, can anybody explain for us why it is the law that in terms of section 7.3, an unlimited company can create shares, and yet there is no liability. There's no limit on its liability. Can anybody explain for us? Anybody?
Yes, my lord. The question again, if you can repeat.
The question is that if you look at section 7, subsection 3 of the Act, that's the Act 992, is to the effect that a company limited by shares and an unlimited company shall, for the purpose of incorporation, be registered with shares. So an unlimited company shall be registered with shares and has the power to create shares by extension. My question is, if there is no limit on this liability, what is the rationale for letting it be registered with shares?
Hello, sir.
Yes.
Okay. I think in the event that the shareholders decide to create some liability by registering shares for themselves, that's why the provision allows for that.
I like your effort, but that is not it.
Hello, sir.
Yes, Richard.
Hello, sir.
Richard, go ahead.
Hello.
Please go ahead.
Yes, sir. So with unlimited liability company, a personal asset can be seized to cover business liability if company funds are insufficient.
Come again.
Yeah, I said with the unlimited liability company, the personal responsibility for all of the company's debts and obligations, meaning personal asset can be seized to cover business liabilities if company funds are insufficient. In contrast to
Yes, go ahead.
yeah, so in contrast to limited liability company, there's no legal separation between the owner's personal asset and their business liabilities.
I mean, all that you have said is true, but my
Hello,
question,
sir.
why? So, what is the role of the shares then?
Hello,
Because
sir.
it's a personal liability. So one person can own the whole company, which the company cannot detach from that personality.
Hello, sir.
Yes, Albert.
Hello, sir.
Yes, Albert, go ahead.
Hello.
Yes.
Okay.
Sir, I
My
believe.
lord.
Sir,
So
hello, my
I
lord.
think ownership is one of the purposes, so that at least at the onset, the owners are known. The owners of the company will be known.
Hello, sir.
Albert, are you done?
Yes, please.
All right, thank you. Now,
Hello, sir.
yes,
Hello,
Richard.
sir.
Yeah, go ahead.
Yes,
So
I believe that even though they have unlimited, there is no limit on their liability. The issue of the share there is for members to know who owns which percentage of shares in the company and what sort of control will exist in such company.
Okay. Yes. Yes. I like that. Yes.
so with this one, say personal accountability is involved.
Right.
Hello there.
Hello, my lord.
Yes. Yes. Please go ahead.
Again, the issue of shares being there is for them to be able to determine who takes this profits and for the company to know how, in case there is crisis in the company, who bears responsibility based on the number of shares each member has in that unlimited sort of company.
Right. Thank you. Yeah. So all of you, you've made a very useful contribution and canvas. I mean, largely, correct points. Yes, unlimited liability company is supposed to register with shares, but there's no limit on the liability. And I wanted to understand the significance of having shares then. Now, the shares serve so many purposes. Among other things, they help us to know who owns what proportion of the company. The voting power when it comes to decision making. When it comes to entitlement to dividends, where profit is made and the profit is supposed to be distributed, in what proportion should you distribute it? So the shares will help us to determine all that. And then if there is a surplus assets unwinding up, after deaths have been distributed, the surplus assets will be distributed pro rata according to shareholding. So therefore, in unlimited liability company, members' liability, as we have seen, is not limited to unpaid capital, unlike commonly limited by shares. But the shares actually define their internal rights and duties in relation to one another. So that is the rationale for actually having shares in unlimited liability company. Now I come to my substantive question. Is an unlimited liability company a multifaceted sole proprietorship and an incorporated private partnership in disguise? Maybe let's say the first part first. Will you say that in view of what we've come to know about unlimited liability company, then it is a multifaceted sole proprietorship?
Malade, if I can try.
Yes, please.
Yes, it is a multifaceted sole proprietorship in a sense that in the event of winding up, the liability of the company is shared among the shareholders so that one person does not carry all that upon him or herself.
Okay. All right. Thank you. Any other?
Fair.
Yes.
In one breath it is, and in another way it is not. It is because it acts in terms of operation. It behaves like a so where in the course of when there is a debt to be paid, the owner's personal assets are used to offset the debt. And it is not because when the regulation allow them to create shares to identify for the purposes of who owns and controls majority of the interest in the business. In that sense, it does not become a multifaceted sole proprietorship.
Okay. Okay. Any other? Richard, is your hand still up?
Yes, sir.
Okay. Let's hear you. Eric, let's hear you.
My Lord, I learning friend rightly said.
Yeah, I think. Yeah, Eric, just type your response in the chat. I think Eric, just type your response. We cannot hear you. Type your response. Okay.
Nature in the sense that
Okay, thank you.
Hey.
It is
Please, if you can,
Yeah, so thank you for your attempts. In terms of functional resemblance, we'll get some resemblance between unlimited liability company and so proprietorship. And we also get the same between unlimited liability company and incorporated private partnership. However, it is wrong to say that unlimited liability company is a multifaceted sole proprietorship in disguise and incorporated private partnership in disguise, as it were, because of other features which are unique to each other. For example, when it comes to management, incorporated private partnership, all the partners are supposed to take part in the running of management. But in a unlimited liability company, there can be a separation between membership and management. Just one example, and there are so many others. So it's known as, yes, there are some similarities on the face of it, but in reality, there are still important distinction based upon the legal character of each of these three vehicles. And we also have external company, which is defined by section 329, subsection 2 of Act 992 as a body corporate formed outside the Republic, but has an established place of business in the country. We've explained this at the beginning. So it is important for us to note that an external company could exist in the form of a company limited by shares, a company limited by guarantee, an unlimited liability company. It could also be a public or private company. So the only difference is that it was registered outside the Republic. So I asked you a question which I want you to think about. Whether for all purposes and in all respects, a foreign company is always an external company as defined. Is it correct to say that every foreign company is an external company for purposes of Section 329 of Act 992? So I'd like somebody to read Act 329 for us. Act 329. Yes, one of our sisters should read 329 for us. Yes, let me just call, somebody. Mercy Safo will read it for us.
Answer.
Yes, go ahead.
Please, the question again.
I said read Section 329 for us.
Okay. Section 329, subsection 1. Sections 330 to 342 apply to external companies as defined in this section. An external company is a body corporate formed outside the Republic, which has an established place of business in the country. The expression established place of business means a branch, management, share, transfer, or registration office, factory, mines, or any other fixed place of business, but does not include an agency unless the agent has and habitually exercises a general authority to exercises a general authority to negotiate and conclude contracts on behalf of the body corporate or maintain a stock of merchandise belonging to the and regularly fills order on behalf of the body corporate. For the purpose of subsections 3, a body corporate does not have an established place of business in the Republic merely because the body corporate carries on businesses dealing in the Republic through a genuine broker or general commission agent acting in the ordinary course of business as a broker or general commission agent, or the fact that a body corporate has a subsidiary which is incorporate, resident, or carrying on business in the Republic, whether through an established place of business or otherwise, does not of itself constitute the place of business of the subsidiary, an established place of business of that body corporate.
Right. Thank you. Yeah, so Section 329 provides the criteria for us to know whether a company is an external company for purposes of our company law. And before it is accorded that recognition, it will have to register certain documents with the registrar of companies. And what are those documents? So take Section 330 for us. Yes.
Hello there. Section 330. An external company which establishes a place of business in the country shall, within 1 month of the establishment of the place of business, deliver to the registrar for registration a copy of the certificate of incorporation, and where applicable, a copy of the constitution, charter, statutes, regulations, memorandum, and articles, or any other instrument constituting or defining the constitution of the company in a language acceptable to the registrar. B, a statement duly notarized in the jurisdiction of origin of the company, giving the following particulars regarding the company. I, the name, the nature of business or other main objects of the company, if any. The present forename and surname and a former forename or surname, and the address and business occupation of one person or more persons in this act referred to as a local manager authorized to manage the business of the company in the Republic. IV, if the company has shares, the number and nominal value of the authorized and issued shares, the amount paid up on the shares, and the amount remaining payable on the shares, distinguishing between the amounts paid and payable in cash and the amounts paid and payable otherwise than in cash. V, the address of the registered or principal office or website in the country of incorporation. VI, the address of the principal place of business in Ghana, including an electronic mail address, digital address, the post office box number, and the telephone number. And VII, the name and address in Ghana of a person in this act referred to as a process agent, authorized by the company to accept service of process and other documents on behalf of the company. C, a statement duly notarized in the jurisdiction of origin of the company giving the following particulars regarding the beneficial owners of the company. I, the full name and any former or alternate name. II, the date and place of birth. III, the telephone number. IV, the nationality and national identity number or passport number or any other appropriate identification. V, the residential and postal address. VI, the nature of the interest, including the details of any legal, financial, security, debenture, or informal arrangement giving rise to the beneficial ownership. And VII, a confirmation as to whether the beneficial owner is a politically exposed person. And D, the particulars and copies of the charges on the property of the company that are required to be delivered for registration in accordance with section 337, or if there are no charges, a statement in the prescribed form to that effect. 2. The registrar shall register the documents in the register of external companies and publish the particulars contained in the statement referred to in paragraph B of section 1 in the company's bulletin. 3.
Okay. So I think you can read, because of time, we'll skip and then you can read the rest. But what you are supposed to read all through up to section now to section 341, and you notice that we have an elaborate provisions on external companies. But just one thing I want to draw your attention to, the fact that the lawmaker is trying to cooperate with emerging international efforts to fight money laundering. And so you notice that particulars of beneficial ownership of shares and so on in external companies are even supposed to be disclosed. Because you don't want a situation where somebody will get the proceeds of a crime from another jurisdiction and come and invest it in a corporate entity in Ghana. And that is why all those provisions are there. But I urge you to read all the provisions on external companies. We'll be coming to them as we do some substantive discussions in other areas. Now, who qualifies to apply for incorporation to get an incorporated company? Well, if you look at the section 12 of Act 992, it's quite clear that subject to this act, a person of the age of 18 years and above may apply for incorporation of a company under this act. So anybody who is 18 years is qualified to take steps to acquire the incorporated company by way of incorporation. And a child does not qualify. No, here we are not talking about what we learned in contracts, where the age of a minor, for long term was understood as 21. Now, our law has moved on. So if you look at the repealed at 179, the Companies Code, before you go apply for registration, or you could be a subscriber, you have to be 21 years or more. But now that has been reduced to 18 years. And I think that that is good because it brought the law in line with provisions of the Children's Act as well as the Constitution. Now, how does incorporated companies come to an end? Because we look at how partnership comes to an end and how sole proprietorship come to an end. So how does incorporated partnership company come to an end? We'll come and discuss this as a substantive topic, but now we're just looking at it as part of business organizations. So incorporated companies are terminated by winding up and dissolution. So the winding up of an incorporated company may be by an official liquidation in accordance with the Corporate Insolvency and Restructuring Act of 2020, Act 1015, and by private liquidation. So if you look at Section 81 of the Corporate Insolvency and Restructuring Act 1015, it stipulates entirely that the official liquidation of an incorporated company may be commenced by a special resolution, petition addressed to the registrar, petition to the court, conversion from private liquidation, and conversion from administration or restructuring of the company. So it may come about in a number of ways, as contemplated under Section 81. Now, Section 289 of Act 992 also recognizes that an incorporated company could be terminated by dissolution with full winding up. So that one is also possible. I will come and discuss all this in details. What are the benefits or the advantages of incorporated companies? Certainly, we've seen there's perpetual succession. We have a business continuity until there's winding up and dissolution. It remains in existence. The members or the shareholders may die, directors may die, but the company will be there. Now, corporate liability is distinct from liability of members and officers, except or save in instances where the veil of incorporation is lifted, because the company is seen as a juristic person. So it can actually incur its own liabilities and so on. Direct liability and also vicarious liability, if you remember your thought. Statutory guarantee and protection of the rights of members. Your right to attend meetings, vote, and entitlement to dividends, all these are safeguarded. And creditors, they also have the right to enforce the debenture agreement of the company. There are a lot of advantages, but we'll just touch on one or two, and I'll leave you to identify more advantages of incorporated companies as you learn further. What about the demerits or the disadvantage? Well, it may be argued that the incorporation process is somewhat cumbersome. Decision-making is not also easy because you need to either get resolutions pass, even if it's going to be outside meeting, written resolution, you have to get other people to agree, or you have to go through the process of convening a meeting. Incorporated companies appear to be more regulatory than facilitative in some ways. Of course, we can debate this, but if you compare with others, in that case, arguably, we could say there's a little margin for independent governance. of incorporated companies. And here too, there are many more disadvantages, so I'll leave you to look for the rest. Now, just before we go, there's something called statutory corporations. Now, a statutory corporation is basically a state-owned body corporate. It's not registered under the General Companies Act. It is set up by a special act of parliament and is set up to discharge a specific public duty. So, statutory corporation in the past was not profit oriented, but in some cases, it may be formed to carry on business for profit for the general benefit of the citizenry. And board of directors are appointed by the government to the relevant sector minister. Then now the problem we have with statutory corporations and in the public sector and so on is that they are affected by political changes. So if you have like a change in the government, then the boards are also going to be dissolved more or less, and you may have to get a new people appointed. Well, statutory corporations answerable to legislature, like maybe Ghana Broadcasting Corporation is one example we can easily point to, or Ghana National Petroleum Corporation. In the 1960s, we had a lot of statutory corporations because of the type of more or less socialist, if you like, economy which we were running. A lot of more welfare state, if you like. But there has been what we call diversity implementation. We've had a privatization where a lot of public companies have been privatized. And if you remember the Diversity Implementation Committee during President Rawlings' reign as the head of state and also as the first president of the Fourth Republic, as part of World Bank reforms that you need to privatize. And a lot of statutory corporations were actually converted to become like a private sector company, not necessarily as a private company. Now, if you look at Article 192 of the Constitution, it makes it quite clear that a public corporation shall only be established by an act of parliament. We have an old legislation which goes back to the first Republic, that is the Statutory Corporations Act of 1964, and it provides that the president may, by legislative instrument, provide for the establishment as a body corporate of an existing organization or body not being already a body corporate, or B, of a new organization or body, provided the existing organization or body shall not be so established unless it is originally constituted by or under the authority of a minister, or is required to act in accordance with the directions given by a minister or otherwise under government control. So that is the legal framework for bringing any of these statutory corporations into existence. Now, a question which arises is whether Section 1 of Act 232, the Statutory Corporations Act, is it consistent with Article 192 of the Constitution? Article 192 says that a public corporation shall not be established except by Act of Parliament. But Act 232, as we saw, says that the president can just establish statutory corporation by passing an airline legislative instrument. Yeah, so, but few issues to ponder. What happens when a statutory corporation is so established? Yes, when it is established, it becomes a body corporate, separate and distinct from its members and officers. But is it right to say that since it is state-owned, liability always falls on the state? I think that is not correct. If it is 100% state-owned, then that is a different matter. Again, when it is established, because it's a body corporate, it also have perpetual succession and common seal. It may sue and be sued in its own name and shall have the power to acquire and hold movable and immovable property. It can enter into contract or any other relevant transactions. We see Section 3 of Act 232. Its dissolution lies at the clemency or the pleasure of the president, as it were. If you look at the Act 232, if you are going by the old legislation, just as the president uses a LI to bring it into existence, it can also pass an LI to dissolve a corporation. Now, we are ending, but I'm giving you a small project. I want you to do a bit of a mini project work on trustee corporations, building societies, and cooperative societies. So, look at the question over there, and I would like you to work through this. I don't know if you have, do you have a groups already?
Yes, sir.
How many groups do you have?
We have 8 groups.
The regular students, how many groups do you have? Regular students, how many groups do you have?
4.
4, okay. Okay, so for the regular students, merge the, let's make it this. Okay, no, just we allow 3 groups. The 4th group will be given work next time. So one group should take trustee corporation. Another group should take building societies, and then the other group should take cooperative societies. Okay, so you are supposed to do the work, sending like a memorandum entailing or addressing the nature of business contemplated by each act. So if we take the Trustees Corporations Act, you do it, building society and cooperative society, and so you do the same thing. Then the establishment and governance of each business model, the legal status and dissolution and the strengths and weaknesses. So you are supposed to take one of these 3 and subject it to the 4 thematic areas or the tasks which have been mapped out there for you. So you will submit it on the platform, and then when we come to class, I'll give you a few minutes for you to present. So that is the regular class. Now, for the weekend class, I need class rep. Let 3 of your groups take this. One group will do trustee corporation, the other will be building societies, and the other would be the cooperative society. So that next time, when there are other work, we give it to the other groups in that way until we've exhausted all of them. And you should also put it on the platform. And when we have a class, I'll invite them to also make a presentation. I hope it's clear.
Yes, my lord.
All right. So we will draw the curtain down here.